You stand and raise your right hand for me, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can have a seat. And this is Mr. Langenberg's. This is file 25-9182PZ. It's a petition for restoration of firearm rights under Michigan law. And the prosecuting attorney is present and entitled to be heard on the question as well. Ms. Goodrich, have you had a chance to review this petition to see whether he is eligible other than the behavior matters?
Yes, Your Honor. I believe that he is.
And
before a single word is spoken in this courtroom, understand what's really on the line here. This isn't just paperwork. This is a man standing in front of a judge asking the government to trust him again with a constitutional right he lost more than 20 years ago. A past felony, a life rebuilt, children waiting at home, and a simple request, the right to hunt with his kids. But in the courtroom, history never disappears. It waits to be examined under oath. Every conviction, every fine, every probation term becomes part of a legal equation that decides whether redemption is real or only theoretical. And what makes this moment tense is that one wrong answer, one inconsistency, one recent mistake could collapse everything. So ask yourself as we begin, how long should mistake follow someone? At what point does the law say you've paid your debt? And when a judge weighs public safety against personal rehabilitation, which side should carry more weight?
so, Mr. Langenberg, you have a conviction from 2003 that was a drug case, is that right, out of this county?
That is correct.
Okay, and you were incarcerated for that and then were discharged from parole 2008, is that right?
7/19 of 2008, yes.
Okay. And you paid off all those fines more than 20 years ago?
That's correct.
And do you have, since you were, was that the only felony that you had?
Correct. I think I had one as a minor when I was 17, but that was the only adult one in none sense.
Okay, since you were discharged from parole, have you been convicted of any offense? Have you been convicted of any crime at all?
Yes.
And what was that? When was that?
2002 misdemeanor retail fraud.
2002?
2022.
Okay, 2022, a retail fraud. Was that in this county?
Otsego County.
Otsego. Okay. Who was the victim of that retail fraud?
Walmart.
Okay. Any other arrests since you were parole?
No,
Okay. Do you reside in Wolverine?
I do.
Do you work?
I do.
Where do you work?
I work for a company called Jabri Tech. We do the storm cleanup for Great Lakes Energy and IAG Electric Company.
Okay. How long have you held that job?
Since April of last year.
Okay. Where were you working before that?
I had my own restaurant. And prior to that, I was a machinist for 15 years.
What restaurant did you have?
Kung Fu Jimmy's,
Okay.
Chinese restaurant in Gaelic.
And you have some kids?
I do.
Do they live with you?
They do.
Right. And you'd like your firearm rights restored under Michigan law so that you can go hunting with them, is that right?
That is correct.
All right, Ms. Goodrich, do you have any questions for Mr. Langenberg?
Yes, for the 2022 retail fraud third degree, it looks like you were just put on probation for 180 days. Did you successfully complete those terms?
I did.
No further questions, Your Honor.
All right, Mr. Langenberg, is there anything else you want to tell us about your application today or no?
No.
All right, well, based upon the testimony of Mr. Langenberg, And the prosecuting attorney has been given an opportunity to be heard on the question. Oh, I'm sorry, Ms. Curtis, did you have any position?
No objection to the relief requested.
Okay. Prosecutor's been given an opportunity to be heard and has no objection to the petition. The court would find by clear and convincing evidence under the statute that it has been more than 5 years since Mr. Langenberg served all terms of imprisonment, and it's had been more than 5 years since he successfully completed all conditions of probation or parole, and it's been more than 5 years since he's paid all fines in full. And I find that Mr. Langenberg is not likely to act in a manner dangerous to the safety of other persons. Therefore, Mr. Langenberg, I'm granting your petition and restoring your firearm rights and signing an order to that.
This is a powerful moment. The judge isn't just granting permission. He's applying a strict legal standard, clear and convincing evidence. That means the court must be firmly persuaded that all statutory conditions are met. Time served, parole completed, fines paid, and most importantly, no likelihood of future danger. The prosecutor's lack of objection matters too. It signals the state itself sees no ongoing risk. But notice the caution. State rights restored does not equal federal rights restored. That's a critical distinction most people don't understand. Federal firearm disabilities can still exist even when a state judge says yes. The judge is protecting this man from future arrest by warning him to carry the court order, because in the real world, a traffic stop could instantly become a felony charge without proof. So the question for viewers is this. Should a decades-old conviction still shadow someone legally, even after court finds him safe? Or is this exactly how justice is supposed to work?
Effect that I'll have the bailiff give this to you. You can walk it down to the clerk's office for filing. They can give you a true copy of that. I want to tell you a couple things about that, Mr. Lane.
Okay.
I am a state of Michigan judge. I am not a federal judge. There are federal laws about firearms. I can do nothing to restore any federal disqualifications that you may have. So you may want to talk with a lawyer about federal disqualifications and enforcement priorities, and whether there's anything to do about that, I don't know. All I can do is restore your rights under Michigan law. So I'm giving you as much relief as I can. The other thing I want to tell you is, if you decide after reviewing the federal situation that you do want to possess or use a firearm, you want to have a copy of this order with you anytime you do have a firearm, because a law enforcement officer that you encounter, if you encounter one, if they run you and see that felony conviction, they may conclude that you're a felon in possession of a firearm, and you telling them that the judge restored their firearm rights isn't going to help you at that scene. You having a court order signed by me would do a better trick with that. Okay, so you want to have that order with you. And then the third thing I want to tell you about that is, I'm not sure whether the retail fraud would interfere with that timeline or not, but it certainly has been long enough that you may want to consider jumping through. There's a little bit more hoops to do it, but getting that prior felony conviction entirely expunged and set aside. And you can get information about that online, michiganlegalhelp.org. We have a self-help center down in the county library. You can check that out and see. It's a little bit more involved than the petition you did, but if you want to get that completely set aside, there's a process for you to get that completely expunged. Okay.
Is my understanding under the Michigan's Fresh Start initiative or whatever that may have already been expunged?
I don't know whether that's true or not.
Still showing up on your record.
It's still showing up. So
okay.
it has not been automatically set aside. Some of them were subject to automatic set aside. Some of them weren't. So the prosecutor says she just checked it and it's still showing up.
Okay.
So you may want to go ahead and check that out. And if I were you, I'd schedule an appointment, check with an attorney about that federal question and maybe an expungement. Okay.
I appreciate it. Thank
Okay.
you.
Good luck to you, sir. All right, and we also have Ivy, the Secretary of State. Anybody present on that?
I'm here, sir, but I haven't seen Dan.
Okay, we'll pass the case then. And anybody here on, is Kimberly Stone present yet or no? It's a little early for that. All right, well, let's go off the record for a minute. All right, that'll bring us to People v. Noah Hansen. It's file 25-7107 FH. All right, and we've got the prosecuting attorney, Ms. Goodrich. We've got Mr. Gilbert for the defense present. We're here for an arraignment and also a show cause. So on the arraignment, Mr. Gilbert, you had a chance to review the charging document?
Yes, Mr. Hanson and I have gone through the charging documents. He knows what he's been charged with and wishes to waive the reading.
All right, well, under a plea of not guilty on the charge of assault with intent to do great bodily harm and reckless driving causing serious impairment. Is a forensic center referral requested?
It is not.
All right, and estimated length of trial?
I'm gonna leave this one up to the prosecutor.
I think one day.
Mr. Hanson, it's alleged that you're in contempt of court for positive drug tests while you've been on bond. You've got the right to have a hearing about those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of a lawyer and to present evidence in your own defense. If you are found to be in contempt, I could jail you for up to 93 days or fine you up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond. Do you understand the rights that you have and the penalties that you could face? Mr. Gilbert, do you know he wishes to proceed about that?
Yes, we'd like to ask for a hearing at this time.
We'll schedule this for a docket call on February 10 at 2:40 in the afternoon. And we'll also schedule that for a status conference on the pending contempt or bond violation at the same time. But given the number of positive tests, I'd like to hear from counsel about whether I should continue or cancel Mr. Hansen's bond. Ms. Goodrich?
Your Honor, he had 2 prior violations in district court. It was a no contact violation on September 25th with a co-defendant, and then an increase in the THC creatinine ratio on November 3rd. So here we are again now with positive drug screens. So I would ask that the bond be revoked at this time.
Mr. Gilbert?
Your Honor, I point out that my client's adamant to me that he's not using. He was around some people that were using. I'd point out that the drug screens I saw did increase on the second drug screen, but now we're dropping. And I would ask that the court, if we continue to monitor or put him on a short leash where if they spike again, that his bond's automatically revoked. My hope is that, and my plan is that by the time we get to February 10th, that those numbers will have decreased off and I can put testimony on that it was a secondhand that made that increase. He did admit to using down in district court, but tells me that he hasn't used since. I'd also point out that I believe he's on a second interview for a very good job with Mueller Aerospace over in the Petoskey area. And I know they are very adamant about testing their employees for drugs. So if that's a continuing thing, that would be a job option that would not work out for him. So my request would be not to revoke bond at this time, but if there is an increase, that it be revoked at that time.
Yeah, I don't know, Mr. Hansen, this is a really serious crime. It's alleged that you've participated in where somebody could have been hurt or killed, and you seem to just blow off your bond conditions. I think I smell marijuana on you from here. I'm canceling your bond right now.
This is the tonal shift of the entire hearing. We move from restoration to revocation, from second chances to immediate consequences. The judge isn't speculating. He's reacting to repeated bond violations, positive drug tests, and what he perceives as blatant disregard for court authority. When he says, this is a really serious crime, and orders remand, that's the court drawing a hard line. Bond is a privilege, not a right. The moment a judge believes you're a danger or noncompliant, liberty disappears in seconds. No jury, no trial yet, just a gavel and handcuffs. And notice the human contrast. One man trusted to carry a firearm again, another losing freedom entirely. Same courtroom, Same law, very different outcomes. So ask yourself, was a judge being firm or too harsh? And how much patience should the system have when public safety is on the line?
Be remanded to the custody sheriff till further order report. All right, I've got somebody appearing on Zoom video. Let me see who they are. That'll bring us then to People v. Courtney Self, file 25-7089 FH. And Mr. Gilbert, we're here for a docket call, and we also have a show cause. What's our status on the docket call?
The prosecutor has provided me with a plea, and I provided that to my client. And also, however, when talking with my client, she is informed me that she's intending to retain counsel. So she would like an opportunity to do that.
Okay. And Ms. Self, it's alleged that you are in contempt of court for violating conditions of your bond by not calling and not testing. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt, the right to the assistance from a lawyer, and to present evidence in your own defense. If you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond at any time. Do you understand the rights that you have and the maximum penalties that you can face?
Yes, Your Honor.
Mr. Gilbert, how she was to plead that?
She would like to request a hearing at this time, Your Honor.
We'll enter a plea of not guilty to the contempt. We're going to schedule this for docket call and a status conference on the pending violations on February 3rd at 1:30 in the afternoon. Then you going to have an attorney by then?
I sure do.
And I guess given that Ms. Self just seems determined to not comply with testing at all, I'd like to hear from both sides about what I ought to do about that thing.
Your Honor, bond is set because it's a privilege and there's conditions to given in order to not be incarcerated, and she has chosen not to follow those conditions. So I'd ask that her bond be revoked.
Mr. Gilbert?
Well, Your Honor, I think we're here on these two instances, 11-18 and 12-1. I don't believe that there's been any, unless I'm incorrect, there's been any violation since the beginning of December. My client has supplied me with a few documents. I've just received these. That one does look like there was a test on 11-18, and it looks like Harbor Hall was closed on 12-1. So I haven't presented these to the prosecutor. Again, I just received these. However, it looks like there might be a defense to some portions, if not all. So I would ask the court to maintain bond, and if she violates hereafter, then revoke at that time.
Myself, I mean, there's the show causes that we've got, and I don't want you to tell me anything about those, but then see, just the report shows plenty of days that you're not even picking up the phone to call. 11-27, 11-28, 11-29, 11-30, 12-6, 12-7, 11-22, 11-23. You don't get to do that.
Your Honor, I check in on.
I don't want you to tell me about it. I'm going to tell you this. I'm not going to cancel your bond today. One missed call, one missed test. I don't care. Sunday you're calling. Every day I get one report that shows any problem in this. I will sign a warrant. We won't have any other hearing until you're arrested.
Absolutely, Your Honor.
And you'll sit for the whole case. Okay, you have to comply with this. This is not optional. You don't get to decide when you comply. You understand me?
Yes, Your Honor.
All right. That's your only warning from me on this. All right, so I'll continue bonds this time. Yeah. myself. All right, do we need Mr. Copeland from the jail, or does
I
council
don't-
want to approach on that, or, well,
We can approach.
okay.
Today's courtroom showed us the full spectrum of justice in action. On one end, a man with a 20-year-old felony conviction met every legal requirement under Michigan law and had his firearm rights restored, proving that rehabilitation, compliance, and time can reopen doors once thought permanently closed. On the other, we witnessed the immediate consequences of bond violations, where drug use, missed testing, and disregard for court conditions resulted in incarceration without hesitation. The judge applied the law exactly as written, clear and convincing evidence for restoration, and strict enforcement for contempt and bond revocation. These decisions remind us that courts balance mercy with protection, second chances with accountability, and rights with responsibility. If you found this case as intense and revealing as we did, make sure to hit that like button. Share this breakdown with someone who loves real courtroom drama, and subscribe for more powerful, no-nonsense legal analysis. Drop your thoughts in the comments. Who do you think the law treated fairly today? And